lot of you are familiar faces, of course. This has become an annual ritual for us here, and I'm glad to be here again this morning. Like I said, most of you know me, but those of you who don't, my name is Andy Cohen. I am counsel for the district. Have had the pleasure of being counsel for a number of years. We come here. I looked last year was I think April 29th, so right around this time frame every year. And as the board members are required, as we know, to have um, by the legislator to have 4 hours of ethics training every year. And that training is to be comprised of sunshine, public records, and ethics laws. So that's what I have planned for everybody this morning. Um, as in years past, I want everyone to know that this is very informal. So if you got questions, lay them on me. Don't worry about interrupting me or interrupting the flow or anything like that. I want it to be interactive. I want it to be beneficial to you that are here to get out of it the most that we can. So I already got a question. The law has not changed. It is not required if you are on a committee that you have this training, but it's certainly something that I would recommend. As we've talked about in years past, and we'll get into this too, but any committee that is a holiday park committee and that is making recommendations to the board is subject to the Sunshine Law. So what goes along with that are, of course, public records issues and such. So certainly would be good to be up on what those laws are if you're a committee member, but it is not required. As a committee member, you do not fill out the financial disclosure form that the board members need to fill out. When the board members fill out that financial disclosure form, as you know, because you've done it, you have to check the little box that says you've completed your ethics training. So required for them, not required for committee members, but who would want to miss this, right? So, yeah. That's certainly a good practice. Absolutely. As we said, it's beneficial, it's helpful to them, but it is not required. Okay. So, some of this, well, a lot of this might be repetitive from prior years, but it'll be a reinforcement. It has been changed, so there's new names, there's some new slides. Um, But we're going to start this morning with sunshine and public records, and then after that, we'll see where we stand in terms of breaking for lunch, and then we'll roll into ethics laws to finish out the day. So um, first, we have a couple of cartoons. They're sprinkled throughout this, but we're starting with the Sunshine Law, and as we know, as we've talked about before, Sunshine Law can be a little inefficient for getting work done, but the basis behind it is well grounded that we want everything to be done in the open. We want our public government to operate openly. No more of these, what you always heard about back, smoke filled rooms and deals being made behind the scenes. The idea is that everything should be in the open. So, what is the Sunshine Law? Where does it come from? Next slide. Thanks. The Sunshine Law is rooted in statutory law and the Florida Constitution. So the Florida Constitution is Article 1, Section 24B. Statutory law is Section 286.011. And the little picture on the right there is the Government and the Sunshine Manual. I've mentioned it before, but those of you who haven't taken a look at that, they have it online too. It's an excellent resource. It's set up with Q&As about, hey, is such and such record a public record? Hey, two people want to do this. Can done. And so it's a really good resource, and it's something that all of us local government attorney nerds have right on the corner of our desk. So the Sunshine Law has 3 requirements. Um, as I said, you know, it's a fairly simple process that generates a lot of questions and causes a lot of complications and makes the news a lot. But it comes down to these 3 requirements. One, meetings of the public board or commission must be open to the public. 2, reasonable notice must be given. And 3, minutes must be taken. So those 3 requirements, we're going to go through those in a little bit more depth and try and flesh out what that means. First one, meetings of public boards or commissions must be open to the public. So, what is a meeting? Meeting equals a discussion of district business. So, next slide. Meetings are defined as all discussions and deliberations by two or more members of the same board, whether that meeting is formal or casual, relating to a topic that is pending before the board or that is foreseeable to come before the board for action. Let's talk about that for a little bit. Those of you that have HOA experience, um, sometimes 2 people can get together when you have an HOA, because with an HOA, it's a quorum of the board. So say you got a 5-member board, 3 people couldn't get together, but 2 could. For us, for our, as we know, we're a local form of government. For governments that are subject to the sunshine, no more than one. So no more than 2 people from the same board can get together. And this talks about, to talk about pending action or something that's foreseeable. I always counsel my clients basically any district business. You never know what's going to be foreseeable, what potentially could come before you. We need to err on the side of caution. So does that mean that, you can't have friends anymore? No. Um, 2 people on the same board, on our board of trustees, can still get together and watch the hockey game. Um, hopefully they'll win soon, the Lightning. And you can talk about the weather, the love bugs, whatever. But you cannot talk about district business. Next slide. So Sunshine Law applies to members of the same board, all of the members of the elected board. All members elect who have won their seat even if they are not sworn in. So this is a question I get asked sometimes. Say that you're having an election, you're running for an open seat, you're unopposed. So you're the shoe-in. You're going to get that seat. Once you know that, even though you're not on the board yet, you cannot be talking to the board members that you will be serving with. So a lot of people say to me, well, how do I get my information? I want to get up to speed. I want to do a good job for this new board that I just got elected to. You can talk with anyone who's exiting the board because you won't be serving together. And you can talk with staff. I mean, Vicky's always here. I'm available, etc. It also applies to members of any committees appointed by the board. And we already had a question this morning about committees. We talked a lot about this in the past. So if you have a district committee that is doing district business and that is making recommendations to the district board, as most do, because that's why I usually set up a committee to do some work for you, analyze, I don't know, social events for, say, I don't know if you have one, but if you had a social committee that analyzed social events for the park and then made recommendations to the board, they would have to meet in the sunshine. There is a limited exception if they're doing what's called purely fact-finding. So if you have a committee and they're just gathering up all the options and then they throw it on the table for the full board without any recommendations, they don't need to meet in the sunshine. The minute they even limit those options, though, that's like a recommendation. So if they gather 10 proposals for social events, we'll stick on that topic, and they eliminated 3 of them. There were 13. They eliminated 3 of them as like, no one will ever want to do that. But they just throw the 10 on the table and go, you guys choose. They have, by narrowing those options, they have made a recommendation. They are a committee that should be meeting in the sunshine. Not difficult, difficult, like we've talked about, not that difficult for the board. Sunshine just means that you're advertising your meetings, you're not talking to each other between the meetings, and those meetings you need to have minutes kept. We'll get to all those requirements. Okay, so we said that that first requirement was meetings of public boards or commission must be open to the public. So what does open to the public mean? That means you need to meet in a facility that's accessible, adequate, and non-discriminatory. You meet here. You could meet in a public library. You cannot meet in a private home. Um, Even though there's an attorney general opinion out there where they met in someone's home, big sign out front, everybody's welcome, it was noticed, please come in. But they still felt that that was like the attorney general did, that was a chilling effect. And so you have to meet in a public place. As I said, this is a public place. Sometimes my boards meet in libraries, something along those lines. Open to the public also means that the public can actually participate and know what's going on. So there cannot be any inaudible discussion. Something that a lot of my board members do, and it's not for any nefarious reasons or anything, but say sitting up here waiting for the meeting to start, board members might be talking amongst each other. Um, you need to be careful with that because you shouldn't be talking about any agenda items or district business. And even if you're not, there's people out there in the audience who are going to be like, oh, they were just talking about agenda item 1. They've already made up their decision, whatever. So something that I always tell you is that appearances matter. So the public has to have the opportunity to participate. That's what open to the public means. You can't have any confidential votes. Where this typically comes up is with our board, as in many boards, when someone resigns or moves away or whatever, then the board is left with the power to appoint someone for the remainder of their term. And a lot of times the way my boards will do it is that you'll send an e-blast out to the community or something and, hey, we have an open seat. Is there anybody interested? And then people would come in and give them a 2-minute opportunity to talk to you, give them your resume, have them give you their resume, etc. A lot of times my board members will be like, I know all 3 of those candidates. They're all awesome people. They're all my friends. I don't want to vote. I don't want to be in a position where I'm voting for one over the other. Can we do like a secret ballot or something like that? You cannot. The vote has to be in the open. Sometimes, I don't know why, but sometimes my board members will say, we know it has to be open. Can we still have a ballot? You can, but there's all sorts of requirements that go with that. Like you have to write your name on the ballot. You have to announce at the meeting, Sean voted for Frank, whatever. So it's not really secret. And all of those ballots get kept with the minutes. So there's nothing confidential that can go on. The next bullet point is that there's no informal or unofficial votes and no polling. So that's something that comes up sometimes. And as a manager, you might go, hey, should we have this as an agenda item? I'm going to talk to the board members and see what their thoughts are, if we even should put it on the agenda. Or should we just go and mow the grass over there? Do we even need to have an agenda item? You cannot poll the board. You cannot send an email to the board members and say, hey, if there's no objection, then I'm just going to go do this or whatever. They have to have a formal vote on most items, unless you already have direction, obviously. You have to have any vote that's going to be taken has to be done in the sunshine, which means at a duly noticed public meeting. The public has a right to view the meeting and hear all discussions. That's repetitive of what we just said. So, public business must be discussed publicly. Avoid public meetings occurring elsewhere. Again, this is an appearance thing, but you need to be mindful. If there's a problem with one of your stormwater ponds, and 2 board members are standing in front of that pond, and all they're talking about is the weather, someone's going to drive by and be like, they were talking about that pond and the agenda item that's supposed to be on the meeting tomorrow, etc. You just need to be careful of appearances, and you should not be violating. So, if you do run into one of your fellow board members at public, don't talk about district business. As this says, avoid public meetings occurring elsewhere at Publix, coffee shops, restaurants, social events, sporting events, on the beach, anywhere. You just need to be mindful of those things. Does this mean the Sunshine Law prohibits social functions? No. So, as we said, you're still allowed to have friends, still allowed to have holiday parties like that, etc. This next slide is important. Well, they're all important, but a meeting, we said it's meetings of public boards or commissions must be open to the public. We talked about open to the public. We talked a little bit about what a meeting is, but this is more about what a meeting is too, which is a meeting is not just two board members talking at public about district business in person. Meeting can take place over the phone, over text, over emails is the big one, virtually, over social media, etc. The first thing I'll tell you, I've drilled this in you in previous years, is don't use social media. Don't use social media for district business. It's just too hard. It creates too many issues. First of all, it creates public records issues because the minute you send a Facebook post about district business, who's got a copy of that record? Vicki and her team doesn't. So then you've become the public records custodian and you got to go chase that record down. Also, you might comment on something and say, I think that's an awesome idea. And then your fellow board member might write in and say, he doesn't know what he's talking about or whatever. So don't use social media. Emails, um, don't text. I'm going to say that too because you do not have, nobody here, board members, has a district issued cell phone. You should not be shouldn't be texting your fellow board members about district business, but you shouldn't even be texting at all about district business. So you're free to text me or to text Vic or to talk to me or Vicki about district business, but I'm telling you, don't text because that creates public records issues because that phone is yours. And even though, we'll talk about this later, but even though it's yours, it's your personal phone, it does not protect it if you're utilizing it for district business because it's about the content, not the ownership of the device. So, all this gets down to, if you're going to be conducting district business with staff or residents, because you're not doing it with your other board members outside of a meeting, use your separate email address that everybody has. That email address is, we have the ability then, if there's a public records request, to segregate that information and produce what's requested. But getting back to the substance with regards to the Sunshine Law is that, as we said, no two people should be from the same board should be discussing district business. Well, it's not just in person. You cannot be emailing your fellow board members about something. And it's the give and take, it's the up and back that creates the sunshine issue. So, while my preference, again, being conservative, is that board members don't email fellow board members at all, you technically could say, hey, fellow board members, here's a bunch of research on, I'll stick with the bonds, on ponds for our agenda item at the meeting on Monday. Don't respond to me. Do not reply all. We'll discuss it on Monday. You technically could do that. I don't recommend it because it's very easy for a board member just to write back and say, thanks, see you Monday. Now you got a problem. So it's best to not communicate at all with your fellow board members. And if you're communicating district business with staff or with residents or the people that you are allowed to communicate with, use your district email address. So what else is a potential meeting? An email or other writing reflecting board committee member views on a particular action that elicits a response from another board member. That's along the lines of what I just talked about, sort of the position paper idea. Do not respond to other board or committee member emails on their position on a subject. Do not copy board committee members on email. So, again, the minute that you copy all of your fellow board members, it's very easy for one to write reply all, great idea, talk to you Monday. Now you got a problem. It's that communication of the up and back. Couple of cartoons. One more. Next slide. The next one is the reply all lady. One more slide. There you go. As I said, don't do that. What about meetings with staff? So, general rule is that board member meetings with staff are not subject to the Sunshine Law. So, when I say board member meetings, I mean one board member. So, one board member can go and meet with Vicki, talk about whatever the district business is, questions you have about an agenda item coming up at that meeting, etc. If another board member happens to pop their head in, stop your conversation. I have had so many lawsuits you wouldn't believe with things that happened in that exact manner. Um, I just dealt with one with a district up in Apollo Beach where there was a problem with the roof. The manager and one of the board members were going to investigate it. They happened to um, show up. So they happened to run into another board member who was there in the clubhouse. It was the clubhouse roof. And they're like, he tagged along, and they went to look at the roof. They swear, I wasn't there. They swear that they didn't say anything or talk about anything together. But there were like literally like 4 ethics complaints that were filed against those 2 board members saying that they violated the Sunshine Law and all sorts of drama. So just don't even put yourself in that position. There is an exception of when you can't meet with staff, and that's when staff ceases to function in a staff capacity and is delegated authority from a board to act and make selections on the district's behalf. So just because someone's job title may be staff, they may be wearing a different hat at some point. So if you've delegated authority to Vicki or a member of her team, and they're actually acting in board capacity, let's say they're actually working with the board, and together the board members and that person are going to make a decision on hiring a new someone to paint the clubhouse or whatever. Um, they sort of wearing a different hat, so you need to be careful that it's not a hard and fast rule. Okay, as we said, Sunshine Law, 100% inconvenient, but it is the law. So, part of having a meeting open to the public is that the public has the right to speak. As we said, you can't have these confidential discussions. Um, Going along with that means that the public has the right to speak. They have the right to provide input, but it's not unfettered. So, Florida Statute 286-0114 requires that the public be provided with a reasonable opportunity to be heard before the board takes official action. So that's something we've talked about, which is I always recommend that you have resident comment at the beginning of your agenda. So that you've got 9 items on the agenda. You do your resident comments first. They have the opportunity to stand up. You give them a certain amount of time. 3 minutes is the typical, although that's not magic. You give them their 3 minutes. They have the opportunity to address the board about agenda item 4 or whatever it might be. And then they have to sit down. And so you're not required to respond to them. They ask you a question. You're not required to respond. They just have the opportunity to provide information. You might say, hey, we're going to talk about that. We'll get to that later in the meeting, whatever. If you change your agenda, you are allowed to change your agenda. So sometimes things come up. You've published an agenda, get to the meeting, um, and the chair's like, oh, something came up in the last day. We got to talk about this today. You can amend your agenda. But if you amend the agenda, you need to make sure that the residents still have the opportunity for comment. sometimes though what will happen too is you're talking about an agenda item, you go off on a little tangent, and all of a sudden you've decided, oh, we need to take action on X. You can do that. But if it was not an agenda item, you need to stop, open it up for public comment, and then take your vote. So the public always has an opportunity to speak on an item that you're going to take action on. Reasonable, we said reasonable opportunity. Reasonable does not mean unfettered. So you can put a time limit on it. Um, they cannot be rude and discourteous. Can't be screaming out. Um, you can remove somebody from a meeting if they are. You can call the police if you need to. I don't know that that's ever been needed here at Holiday Park. Seemed pretty chill, but I certainly have had districts where we've had to have police presence. Um, so yes, everybody has the opportunity to participate, but they don't have they don't have the right to be disruptive. They don't have the right to be discourteous. There is a difference between public comments during meetings and public hearings. As you know, sometimes you'll have an agenda with a public hearing. Most most of the times it has to do with your budget, and people will have a second bite at the apple at that. So during a public hearing, you're always opening it up for public comment, and people have an opportunity to address whatever that issue is for the public hearing, whether it's your budget or whatever else it might have been. When there is a public hearing, then the public's rights should be greater than normal limits to avoid due process issues. Again, they have what I call that second bite at the apple when you're having a public hearing. Public's right to speak. The Sunshine Law does not prevent the orderly conduct of public participation, structuring agendas to provide one or more time frames to comment, adopting time limits on public comment, and civility code adoption and enforcement. I have some boards that provide for an opportunity for public comment at the end of the meeting as well. You have to do it at the beginning, at least I recommend it, so that you're not stopping for every agenda item. Some boards allow it at the end too. You're not required to, but that's something you can do if you think it's beneficial. I mentioned it briefly before, but you do not have to engage. So someone might stand up here and say, hey, board, I want to know what you're doing about that dirty pond behind my house or that pothole in the road. You could say, thank you for your comment. You could leave it at that. You could say, we're going to be addressing it under agenda item 6. But you do not have to right then and there answer their question or get involved in a give and take, which happens a lot. You say, well, that pothole's going to be filled Monday. And they'll be like, why isn't it going to be filled before then? And then you're up and back and up and back. You don't have to do that. And it lengthens your meetings. Sometimes you may want to, and maybe something that's very important to the community or whatever. But keep in mind that the public just has the opportunity to address you. Okay, so that was our first requirement. Meetings of the public boards or commissions must be open to the public. Requirement number 2, reasonable notice of such meetings must be given. So, what is reasonable notice for special districts? According to the Florida Attorney General, the general definition of reasonable depends on the facts of the situation and the board involved. Well, we actually have guidance for special districts like Holiday Park. We have to publish in the newspaper. Nobody reads the newspaper. I get it. We have to publish in the newspaper at least 7 days ahead for all meetings of the board and of committees that are meeting in the sunshine. What we do, what all districts do mostly, is establish a schedule for the year, which I know you have. We meet on the second Thursday at 2 o'clock or whatever it might be. And you publish the schedule for the entire year. And then, if you need to cancel a meeting, you don't need to publish that. You're free to cancel it. I always tell boards, just put out as much notice as you can, whether it means putting a sign on the door, putting it on your TV station, putting it on the website, etc. Too much notice is always a good thing. And getting back to that, even though you have to publish in the paper, Um, I have boards say like, nobody reads the paper. Can we put it on our website? Can we let them put some signs out front? Yeah, you can always do more notice, but you have to meet that one requirement. And what if you need a special meeting? What if something comes up? Um, you would have to do special notice 7 days ahead in the paper before you can meet, unless it's an emergency. We'll talk about that in a second. So, Florida Statute 189015 sets minimum notice requirements for all special districts. File and publish the day, time, and place of regular meeting on a regular basis, and publish the day, time, place, and purpose of any special meeting at least 7 days. Emergency. Yes, ma'am. If they're meeting in the sunshine, so these, unless they're just doing fact finding, then yes, absolutely. They have to adhere to all of the same rules that the big board does. So I did throw out there that you may not have to publish if it's an emergency meeting. So what's an emergency? A lot of times people will be like, some of my boards will be like, hey, we forgot XYZ. We're going to throw together a meeting tomorrow to talk about it. It's an emergency. That's not an emergency. An emergency is health, safety, and welfare. And really, the only thing, stuff does come up, I get it. But the, the one thing that I have seen with my boards that's typically allowed them to meet on an emergency basis is unfortunately storms. So, we had a good year last year, but we don't always, obviously. um, so hurricanes, something like that, you may need an emergency meeting. And in that case, when you have to have an emergency meeting, you can do it. Um, but any action taken at an emergency meeting requires subsequent ratification by the board at the next regular meeting. So if you have an emergency meeting and you took some action that needed to be done in the heat of the moment, at your next regularly scheduled meeting, ratify that action. Put it on the agenda, ratify it. You can never adopt a budget using an emergency meeting. The purpose of notice is so the public can attend. So, um, as I said, there are certain statutory requirements that set the bottom bar, the minimum, but feel free to use whatever means are available to you in addition to that. I have boards that put a sign out by the gate. Hey, the board meeting is Tuesday at 6 o'clock. Put it on the website, whatever else you want to do. So that is always something that's available to you. Okay, we've done requirement one. We've done requirement two. Third requirement: minutes of the meetings must be taken. So there's no magic there. They could be skeletal. In fact, I recommend they not be verbatim. Some boards insist on that, but I think it creates some trouble because then everybody is like, well, you left out the word the, and we said the word the. So verbatim minutes you can do, but sometimes it's problematic. So skeletal minutes are what 99.9% of my boards utilize. It is allowable, and you basically should be aiming to capture all of the action that took place during that meeting. If a motion was made and seconded and action was taken, that should show up in the minutes. You should have a record of who was present, who was not, when it was convened, when it was adjourned. As to what you want to put in there in the middle of all that, sort of a stylistic thing, but just try and capture the major things. You don't have to tape or record your meetings in any manner, but if you do, that becomes a public record. Sometimes I get asked, well, what about a resident showed up and they put a camera in my face on a tripod and they recorded the whole meeting? Are they allowed to do that? Yes. It's a public meeting. They are allowed to do that. Um, okay, so we said minutes must be taken. What is required? defined as a brief summary or series of brief notes, should reflect board action, must be promptly recorded and open to the public for inspection. So even draft minutes are a public record. So a lot of times you'll have a meeting, you have draft minutes, you may have them on the agenda for the next meeting for the board to review and make any changes or whatever. But in the interim, someone says, I want those draft minutes. A lot of times my boards will be like, well, they're not final yet. We can't give them to you. No, they're a public record. You can stamp draft on them, and these aren't final yet and subject to change, but they're a public record. So staff can prepare minutes for board consideration. Magical minutes do not exist, like we said. What is not required within the minutes? They do not need to be verbatim. It is inconsequential to capture who said what to whom. There's no requirement to record meetings through an audio or videotape. We already said that. Okay, so that is the 3 requirements of the Sunshine Law. What are some exceptions, if there are any? Well, there are some very, very limited exceptions to the Sunshine Law, especially as it applies to a board such as we have here with a Park and Rec district. Collective bargaining, strategy sessions, we don't have that, so that doesn't apply. Risk management, that's typically not going to apply. Ongoing litigation is an exception. It's something called a shade meeting. And shade meetings mean that the full board can meet with the attorney outside of the sunshine, but it's really complicated and limited. So it's only for pending litigation, meaning case has been filed, case number assigned. So let's say someone trips and falls in the clubhouse and they're like, broke my leg. I'm going to sue you unless you pay me $500. The board might go, it's worth it to get rid of this potential claim for $500. We want to talk to the attorney about settling this. In anticipation of litigation is not pending litigation. So you can't have a shade meeting. If that same example, they had sued you, and now they're offering to settle for $500, you can meet with the attorney outside of the sunshine. But there are a lot of requirements, one of which, special notice, special announcements, one of which is that, no problem. They wanted to contribute. One of the things about the shade meeting is you have to have a court reporter present the whole time. And once the litigation is over, the transcript becomes public. So, again, that's really the only exception that would apply to you guys, and it's only for pending litigation. And if you ever did have pending litigation, I would walk you through how that would work. So, okay, we know what the Sunshine Law is. We know there's pretty limited exception. What if you screw up? What are the penalties? A knowing violation constitutes a second-degree misdemeanor, punishable by 60 days in jail and or $500 fine. So there's jail time, there's fines. Non-criminal infractions committed without requisite knowledge is punishable by a fine. Both penalties pursued by the state attorney's office. That's important because a lot of times my board members will go, that fellow board member did a sunshine violation. We want to remove him from the board. You fellow board members don't have any authority over that. You do not prosecute sunshine violations. You do not remove people from the board. The governor removes people from the board. Any action taken in violation of the Sunshine Law is void ab initio. In civil actions, the law provides for recovery of attorney's fees. I'm going to get back to that one. You've heard me talk about it in years past. For violations. Important. Board members acting on advice of legal counsel is a defense to attorney's fees being assessed against the individual. So, I mean, you should be listening to me anyway, but if you don't want to listen to me, keep that in mind. Here's some real world examples. The first one is Citizens for Sunshine versus Chapman. This right up the street, there's Yes, ma'am. So, trustees. Let's separate that for a minute. One trustee. Back up even further. Trustees should not be members of the committee. We make them liaisons, typically, if you have one at all. Um, as a liaison, you can attend the committee meeting, one board member. You can participate. You are not on that committee member board. So you can attend, you can ask questions, you can respond to things, you can participate as much as you want. No two board members should be at any committee meeting participating. So, nor should you be at an HOA meeting or something or some other, group of the park. Um, so if two, do, I'll get back to you in a second. If two do show up, um, you should just sit there with your hands folded. I mean, you're still resident, so let's say a committee has something going on that's really important to you, and you want to hear what they have to say, but there's another board member there too. Um, you both can be there. You shouldn't be. I mean, it's best not to be. But if you absolutely want to be there, you both can be there as long as you sit there with your hands folded and do not engage in any up and back. Yeah. Well, hold on. So they're on the committee, and they're also a board of trustee, a member of the board of trustees. They can do that. They can do that. The problem comes in when you it's always that up and back. It's always the give and take. So if you're there and a fellow big board member is there, a fellow trustee is there, you ought not to be engaging in any conversation. Even though you may say, we're not, in a locked room somewhere, we're in front of everybody for everybody to hear. But it has not been noticed as a board of trustee meeting. Yes, they should not be talking. They shouldn't. I mean, you know, maybe if they're just saying giving some facts or some history and the other person's not talking or whatever, but why put yourself in that situation? The best thing is to just sit there with your hands folded, as hard as it may be. Yes, sir. um, if the other trustee is there and you're going to be, engaging in up and back with the other trustee, you can't do it, as hard as it may be. You can run and get staff, or you know, but you cannot and get be at a meeting with another trustee where you guys are both talking about district business. It's just not advisable. So, again, we're walking a fine line here. Um, I'm going to always err on the side of caution and say it's best not to, because then they might have just thrown out information, historical information, okay? But then you might go, no, you actually didn't remember that correctly. XYZ really happened this way. Mhm. Okay. It's better not to be in the situation at all, obviously. But if you find yourself in a situation where you show up at a meeting and another board member shows up, best to remain quiet. And yeah, okay, maybe the one board member just said something about what the weather, that there was, 3 rainy days last week, and you didn't say anything in response. Be like, okay, that technically wasn't a violation, but you could have stood up and said something else, and then you could, so don't put yourself in the situation. Um, yeah, yeah. Now that's a good question. So even on the same board, let's say that um, the board is looking at a contract for landscaping. Okay, it's on the agenda. But you want all of the board members to do their due diligence and provide their comments. Say there's two or three vendors being looked at. I don't know. Um, they would then send their comments to you, Vicky, and then you would assemble those comments and have them in the agenda package for the next meeting without the people's names on them. So you're right. Like you said, you can't be a conduit. So Sean can't say, hey, Vicky, tell my fellow board member X. And then that other board member can't say, hey, Vicky, tell Sean he doesn't know what the hell he's talking about. Um, so you can't be a conduit. But in that example that I just said, everyone could send you their information. And as long as you take their names off it, so you're not, all board members don't know where they're coming from, then that would be fine. And then at the meeting, certainly you could pipe in and be like, I talked to ABC Landscaping's three references, and they had great things to say about them, whatever. But you can always take information. If you're getting information from different board members to assemble to provide to the group, it's best to take the names off. Sure. So, sure. So everything that we're talking about here for the board with regards to sunshine law, when we say that a committee is subject to the sunshine law, it's exactly the same. You're subject to the sunshine, you're subject to all this stuff. If you're not, you're not. So we have some real world examples. Citizens for Sunshine versus Susan Chapman. Here it was, like I said, just up the street in Sarasota. City commissioners were alleged to have violated the Sunshine Law by attending a community-sponsored luncheon on homelessness. After a 2-day trial, the judge found that the commissioner's decision to attend the community meeting did not technically violate the Sunshine Law, but those holding public office should always endeavor to avoid even the appearance of impropriety. The important part of this case is that the city, quote, won, but they spent $400,000 in repairs. So, the only winner there was my daughter's college. So that wasn't me, by the way. I didn't represent. I wasn't in that case. But another real world example is Escambia County. Former president of the Florida Senate and chairman of the Escambia County Commission was convicted of a sunshine law violation for discussing public business in private with other commissioners. He served 49 days in jail and was ordered to pay $500 plus $3603.85 in court costs. So, all of this huge money that you board members get paid, I know you're all in it for the salary. Um, don't find yourself in a sunshine violation. Really can't. It's not frequent, but jail time is it has happened. I mean, here's more about this real world example. At the sentencing, the judge said his crimes were more serious because he ignored the advice of the attorney, played a leadership role, and had vast political experience. Here's just a little bit more information on the case. And the court advice for officials was meeting of two or more members are not allowed if any of the words pertain to possible foreseeable issues unless the meeting is open and noticed. Rarely is there any purpose for a private communication between two members. Informal or unofficial pass you in the hall information gathering by two members is subject to the Sunshine Law. Any attempt to distinguish between formal and informal or just listening meetings between two members is by itself alien to the Sunshine Law. That gets a little bit towards some of those questions you were asking, which is, you know, okay, that factual pattern happens. Someone goes crazy, files a lawsuit, you find yourself in court, you win. What was the win? You still spent a lot of attorney's fees. So, I mean, things happen. We all know things happen. But try to not put yourself in those situations. Because a violation of the Sunshine Law can be charged as a crime, all those prosecutorial techniques, such as subpoenas for cell phone records, are just a signature away. When in doubt as to whether a communication directly or indirectly between two members may be illegal under the Sunshine Law, leave. So getting back to that example that I had before with the two board members or the one board member happened to find the other one at the clubhouse and they went to go look at the roof with the engineer. Don't go. Leave. You shouldn't have done that. It again, as it turned out, there were no charges filed, but there was ethics commission involvement. There was attorney's fees involved. It's like, why did they put themselves in that situation? Here's some pictures of that lawsuit. Here's the booking pictures. Key to the Sunshine Law: only engage in discussion of board topics with your fellow board members in a public meeting setting. Okay, a couple more slides. Now it's quiz time. We always have our quizzes. Um, this one's fairly short this year. So, number one, what are the basic requirements of the three basic requirements of the Sunshine Law? Meetings must be open, reasonable notice provided, and minutes taken. Number two, can trustees use emails to discuss an upcoming agenda item? No. Board may not engage in private discussions of board business. Should boards use a luncheon meeting to conduct board business? No, because it may have a chilling effect on the public's willingness to attend. True or false? The Sunshine Law requires that boards tape record their meetings for minute preservation. False. And then number five, can a board use secret ballots to elect their chair and board offices? No. All right, so that's the Sunshine Law. Next will be public records. I don't know if we want to take a quick little 5-minute break or you want to roll into it, whatever. All right. they're making any substantive changes or not. Or okay, yeah, we'd have to look at it. All right. All right. So um, now we're going to head over to public records. But if there's any questions lingering about sunshine, yes. Right. Mhm. Well, I mean, the quick answer is no, okay? Because of all the issues that we talked about before with appearances and all those types of things. But look, okay, I recognize that sometimes practical overrules what may otherwise be. So if there's any way at all to have just one board member and a staff member, whatever, that's always going to be my recommendation. If it absolutely positively has to be two board members, can they do it? Yes, as long as they're not discussing anything or having any conversation. But it all gets back to what we've been talking about this morning, that someone's going to drive by. I saw them both. They were talking about whomever hit the gate arm and the fine that they're going to impose, etc. So, you know, if you can, try to avoid it. If you can't, you can't. I mean, it is what it is. But know that having two board members out there carries some risks. Yes.
My question is, um, can another younger full-time resident be trained to work with a trustee to do that? We have a lot of people in like the men's club and just us girls or stay here year round. And that would avoid the whole issue.
If you have other people that are willing to participate and can be trained, the board wants to move in that direction, absolutely.
Really the board setting this? Okay, it's not really the board that set that policy. It's just something that happened because the office is responsible for getting those gate arms back up. And the only people that volunteered to help happened to be some board members. Now that we understand this better, we're going to have to seek some other residents that will also volunteer to be in that pool.
That would definitely be a
All
good
right.
idea.
Thank you.
And a regular resident would not have access to the key to get into the box. That would be a problem.
Yeah, one board member, one resident, not a problem.
I'm chair of the Pavilion Committee. The development of the committee was a men's club committee. And at some point, unbeknownst to me, it became a board committee. Was never told this until this year. So we weren't having public meetings. Maybe we should have, I don't know. But I'm not that familiar with this law. So anyway, this year, this winter, we have been operating as best we can under Florida sunshine rules. So this is just a secondary question to this, but the other day, I say we, not the committee, there was a meeting with the electrical contractor discussing what the possibilities would be for how to power this pavilion in the future. And I was not at that meeting, but I'm the chair of the committee, and I feel like I need to be aware of what happened so that when I'm working with the committee, I can be relevant. So my question is can I talk to Bob, who is a liaison for us, and find out what the electrician had to say? So anyway, that's my scenario.
Okay. So you can talk to staff. I don't know if any staff members were present at the meeting. If Vicky has her hand up. If Vicky was present, you're certainly free to talk to Vicky and say, hey, what happened at the meeting? What did the electrician have to say? Things along those lines. When you mentioned liaison, if there was a liaison, so a trustee who's not a member of the committee was present, you can speak with them. You just can't speak with your fellow committee members. You could not call one of your other committee members and say, hey, Jim, what took place at that meeting I missed?
I had emailed you about this, and thank you. I had emailed you, Andy, about the particular committee that Merlin is speaking of, the pavilion, our new pavilion that we're putting in. And so they were initially, this was because these were donated funds, but they are held in our operating general fund. And it was formed, if you will, through the men's club, as I understand as well. So, but there was a time as I know that when I came on board as the manager, I was seeing some of these meetings taking place, and that it was going to be coming to the board for recommendations and who the contractor, would be, and some fact gathering information, but also recommendations. And so that's when I sent the email to you to ask about the Sunshine Law and are they considered a board appointed committee, which the response was yes. And so that's when we started meeting, and they started meeting in the Sunshine Law. So that's how that came about, and the direction given. So I just wanted to make sure that that was clear, that as soon as we saw the direction that the Pavilion Committee was going, that it did become part of the Sunshine Law and was meeting in open public meetings.
That's great.
Okay. Oh, and with the electrical meeting, I think that's just a communication. We had, the contractor was here and an electrician was here to do some other work. Don't know if, well, now it's been brought into a workshop meeting, and that was all discussed in our workshop that the board is moving that forward into our next regular meeting with this particular electric company, and what the options are. So, but that was with the electrician that was here, kind of grabbed them and said, hey, can you speak with our general contractor to help guide them before they start pouring concrete and things like that.
Yes.
Andy, I'm a little confused with what you just said a bit ago.
Okay.
That the chairman of the pavilion committee can talk to the trustee one-on-one?
Sure.
And why is that not a conflict of the sunshine law?
Because they don't serve on the same board or committee. So if you
But they are both subject to sunshine, correct?
they're both subject to sunshine in different respects. I mean, just like, let's make it easy. So, Sean could speak with the chairman of the Trailer Estates Park and Recreation District. They're both subject to sunshine, but they don't serve on the same board.
Thank you.
Sure.
So in this case that we're
We,
talking,
we specifically, and we do this for a reason, and I assume you're following it, is that every board member, not every board member, but I'm guessing, this is the way you have it set up, is that certain board members have certain responsibilities. So I'm on the board, but I'm also the person that deals with maintenance, grounds. And so if there's a maintenance committee, I'll be the liaison to the maintenance committee. But I am not on that committee, and we make it clear that you're just a liaison to that committee. Because if you became a part of that committee, then you can no longer talk to those other committee members. Any other sunshine questions? Or if anything comes up, as I said, just feel free to interrupt. This is for everybody's benefit. So. Except you, no questions from you.
That I'm used to. Oh, boy. And I am used to that. Okay. So I'm going to take that a step further. So we're at you're at the committee meeting. The liaison talks to the other, is talking in the committee members. You have another board member who shows up. He sits on his hands, doesn't say a word. That's fine.
That's fine.
He can't say, okay, all right.
Again, it's fine. It's best if he's not there because of all these things we've
Right.
talked about. You know,
Gotcha.
Someone's going to walk in and be like, I saw them talking, even though you sat there and shut up, okay?
Right.
So, there's all these concerns. But if you truly are just there, sitting on your hands, listening, don't say a word, it's allowed. It's allowed.
My time with the mic is done.
All right. We'll talk about some public records. And as I said, if any other questions come up during, feel free to raise your hand. So, public record. A public record is any document, got a long definition, any document, papers, letters, maps, books, tapes, photos, films, sound recordings, data processing software, or other material, regardless of physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance or in connection with the transaction of official business by an agency. So that was a long definition. But we're going to dissect that a lot. The next slide says that a public record is any material prepared in connection with official agency business intended to perpetuate, communicate, or formalize knowledge. Let's take a step back, and we're going to get into this further. But public record is defined by content, not by medium. So it could be like 3 words scrawled on a napkin, but if it was something having to do with district business and brought up at a meeting, then it's going to be a public record. So it's the content that we're always looking at. With that content, it needs to be prepared in connection with official agency business. So let's start an example. So you're a board member, you're sitting in a meeting at the table, you're scrawling on a sticky note your grocery list, okay? Even though it took place during the meeting, it's a personal item, it's not a public record. Nobody can ask for a copy to see how many bottles of beer you're buying or whatever. So, but let's say that you make some personal notes for an agenda item. You're still in that same meeting. They're just your personal notes. You do nothing with them. You're just referring to them during the meeting. They'll stay your personal notes. But if you take those personal notes and you read them into the record, you say, hey, I prepared for this meeting. I talked to 3 different people. They told me X, Y, Z. I'm reading from these notes. Those notes are now a public record because they were used in connection with official agency business and intended to perpetuate, communicate, or formalize knowledge. In other words, the information in there was conveyed outward. So that is a public record. And if you stamp draft on it, let's say that your manager is working on the budget and they we'll pick on Vicky. Vicky prepares a draft budget and it stays on the corner of her desk. It's not a public record. The minute she transmits that to the board members and says, here's the draft budget, don't reply all, we're going to discuss it at the meeting on Monday. Even though it's got draft stamped all over it, it's a public record because it's district business, used to perpetuate knowledge, it was conveyed outward. So, as I said, there's no unfinished business. Just by stamping something draft, it's not necessarily going to protect it if it otherwise fits the definition. There's a little chart here on this next slide. Record is sent or received. Is the agency information being perpetuated, formalized, or communicated? No, not a public record. Again, those personal notes, even though they're about district business, they stay on that desk. You don't read from them. You don't do anything with them other than maybe refer to them during the meeting. Not a public record. Is the agency information being perpetuated, formalized, or communicated? Yes, public record. So public records, as we said, are determined by content. The means of record transmittal is immaterial. Records sent from or received by personal devices, like a cell phone, personal email account, handwritten notes, are a public record if the content relates to public business. So, let's say, as I talked about before, you're using your personal cell phone. You're not violating any sunshine laws. You're just texting with Vicky about the budget. Then somebody says, I want a copy of those texts. You can't go, well, it's my personal cell phone, so you don't get to see those. It's about the content. So if those were texts about district business, unless you saved them, well, you shouldn't be doing it. But if you are, you need to save them because someone could potentially ask for them. So, like we talked about before, all this money that you guys get, not enough to make you the public records custodian. Use your separate email address, and that is the way you should be communicating with residents, with staff, etc. about district business. Because then if somebody says, I want to see all emails and texts from Sean about the budget over the past 2-week period, you could say, there are no texts. Sean doesn't text because he listens to everything Andy says. And emails, it's easy because they're not interspersed with your grocery list and all of your personal type items. You've got them all right here. You just go in, you pull down the ones over the last 2 weeks, you send them off. That's the way this should be happening. Messages on social media accounts, Facebook, Nextdoor, etc., are public record if the content relates to public business. That's what I mentioned before. Not only are there sunshine issues, but there are multiple public records issues because if you're posting stuff on Facebook about district business, who's keeping those records? You need to be. Yes.
If it's just used to announce meetings or problems, like the front gate is not working today, are those considered public records if they're on Facebook, our Facebook page?
Yes, they are. So, the district has a Facebook page, which I assume you do. And you need to know that the records on there are, even if it's just meeting Monday, see you there. That's public record. And, I'm assuming that Vicky and team have the ability to pull down some of those records if they had to. The problem lies when you post on the whatever Friends of Northport Facebook page about something having to do with the district, and then
So Andy, I have a real quick question related to that. When we do meeting postings, when the office does it, they put it on Facebook and they also send it out on a text messaging system. And it's the exact same identical message. Because it's on two different mediums, do you have to maintain two different copies of it, even though it's the exact same thing? Okay,
Someone
thank
could ask for the text, that you would just
Okay.
say, what's the same, here it is. Public records are determined by content. As we said, drafts and notes that are shared are a public record. Personal records that have nothing to do with public business remain personal, even if on a district-issued device. So let's say you did have board members, I know you don't. Let's say you did have district-issued cell phones, and you were texting with your spouse about the grocery list. Someone says, I want to see that grocery list. Just because it's on your district-issued cell phone doesn't mean they get to see it. Again, it's all about the content. Public records, personal devices, and accounts. Board members posting comments relating to public business on a private website would be responsible for ensuring that the information is maintained in accordance with the Public Records Law. That's what we just talked about. Public employees' private cell phone text use can create an electronic public record if the message is prepared, owned, used, or retained in the scope of agency employment. Private messages may have to be reviewed by a court to determine if they are actually public business, i.e. by visibly texting on a private cell phone at a public meeting. So a lot of times, like I mentioned before, you're standing up here, you're sitting up here, public meeting, two board members are talking to each other. Someone out in the audience might go, well, they were talking about agenda item 6. And if you start texting, even if, again, I keep picking on grocery lists, but you and your spouse are texting during the meeting about groceries, they might be like, well, then I saw that other board member do a text too, and I think they were talking to each other. And so you need to be careful of those types of things. And again, if you're texting and it's only private issues, but let's say you did screw up and you interspersed some district business by texting on your cell phone, now they're going to get to see your cell phone, and they're going to get to have to right to examine it and take out the public things from the private things. And so just don't even get involved in that. Just only communicate on your separate email address. Who can request a public record? Anyone. So they don't have to be a resident of the district. We know that. I mean, you get these different groups across the state, across the country, across the world. They'll be like, I want to see the records from your district having to do with pool maintenance or whatever. They're entitled to them. So every person has the right to inspect or copy any public record. Factors you cannot consider. You cannot consider their motive. So you can't say, if they say, I want to see all of the chair's emails over the past month related to mowing the grass. You can't say, why do you want to see those? Or, and if they identify themselves as Mickey Mouse, you can't say, until you tell me who you are, I'm not providing them. They don't have to provide a motive. They don't have to be a resident. They don't have to identify themselves as long as you have a means of responding. So if they say, I'm Mickey Mouse and this is my email address and this is where I want you to send the records, that's okay. You can't say, you put it on our form and then we'll respond. They could, going back to my napkin, they could write it on a napkin and say, this is my email address, give me this stuff. And again, we'll get to what's exempt and what isn't, but assuming that it's truly a public record and they're entitled to it, they would get it. As I said, you don't have to fill out a form. Doesn't matter how many times they make requests. So I don't know about this community, but I have a lot of communities where we all know who the people are. We all know that after a meeting, we're going to get like 6 public records requests from this particular person. We're entitled to do some of the things I'll talk about, which is, have time, charge in certain instances, etc. But you can't go, you've already made 6, you don't get any more till next month. They're entitled to the information. Requests for public records can be verbal, Copying costs are prescribed by Florida statutes. So you are entitled to charge for copying. You are entitled to charge what special service charges may be imposed when the nature volume requires an extensive use of IT resources or clerical or supervisory assistance. Well, what the heck does that mean? Okay, nobody knows. All right, there's tons of opinions out there trying to interpret that. But what it basically means is that if it takes you a significant amount of time, you can charge for that time, and you can charge upfront. So if somebody says, I would like a copy of, we'll go back to that budget, of that draft budget that was discussed during the meeting yesterday, and they send you a request for that. You can't say, sure, it'll be $5 million, okay? It takes you 2 seconds to press a button, you send it to them. You also can't say, it'll take me a month to get it to you. If it's simple, I mean, if it's, Friday at 6, you could say, I'll get it to you on Monday, but you have to respond in a reasonable amount of time, and the costs need to be statutory. You technically could probably charge like a quarter. I wouldn't recommend it. I mean, if it's something easy and it's just pressing a button, send it to them. But if they're asking for something that's going to take like 10 hours of staff time to assemble, then you can charge clerical rate for that request, and you can use a reasonable amount of time. So if it's going to take 10 hours, it might take you 3 or 4 days, especially if you're busy with something, to respond. You can tell them up front, it's going to take 10 hours, clerical time, $40 an hour, whatever your clerical staff rate is, and we'll have it for you in a week. Then you can require that they pay that up front. So in my example, 10 hours, $40 an hour, say it's going to be $400. They would need to say, yes, I would still like it. Here's the $400. I'll look for it in a week. So you have to give them that opportunity. You have to tell them how much it's going to be, and then they have the opportunity to pay that. The other thing you have to remember about public records is that you don't have to create a public record. So if somebody says, I would like a summary of all discussions over the past 2 weeks by the board members, emails about landscaping. If that summary exists, let's say you had created it for a meeting or something, provide it. If it doesn't, you're just required to provide that information. You can say, well, I have the emails and I can provide those to you, but we don't have a summary. They can't go, well, make me a summary. You're not required to create records. Okay, so what about communications with the district's attorney? It's a lot more open than you would think. So really most communications, even though you might put on it or I might put on it attorney-client privilege or whatever, it's not, okay? 99% of the time, everyone's going to be entitled to those records. There are very, very limited exceptions like trial strategy, things along those lines. But basically, don't expect a privilege in a written communication with the attorney. Written communications sent between a board member and the attorney are a public record unless statutorily exempt. Limited exemption for communications relating to active litigation or labor negotiations, which we don't have here. Once litigation is completed, the record is subject to disclosure. Now, there are some exemptions from public records. Those are set by the legislator. So classic things you might think of, like, let's talk about a personnel file. A personnel file is actually a public record, but there are certain items in there which may not be, like a bank account or a social security number. And if there is exempt information in there, you don't get to hold back the entire record. So let's say someone says, I'd like the personnel file of whomever, and there's a social security number in there. You would have to redact that social security number and then otherwise provide the information that is a public record. And any information that you do redact, you have to cite your basis for it. So there is a specific statutory exemption when, you know, section ABC XYZ, social security numbers are exempt, you would cite that. Advisable to have the agency's records custodian perform these functions. Yeah. Unless they are, there are certain exemptions for like law enforcement people um, and things along those lines, but unless something like that came into play, a home address is not exempt. I mean, I could pretty much get it by Google anyway, probably, but is not. Um, that last point about advisable to have the agency's records custodian perform these functions, the records custodian should be the one in charge of the record, and that is either Vicky or someone from her team. So if you have a resident that says to you, hey, I would like all of your emails relating to the budget over the last week, and you've been good, you've only done emails on your separate email address, um, let the records custodian respond. Don't respond separately. So everything should be funneled through the records custodian. One is it keeps a good record. Two is the records custodian may know something that you may not about something that's exempt. Three is if they don't, the records custodian might reach out to me. So you should not be responding directly. Here's some examples of exemptions from public records law. Firefighter personal information, social security numbers, security or fire safety system plans, including evacuation plans and audio, video security footage. I want to talk about that for a second. That's something that actually comes into play a lot with my district is, and it may have with you, is that I know the gate is a big topic. It always is in a lot of my communities. Let's say someone ran through the gate and smashed into the car in front of them because they were tailgating. The car that got smashed into might call you up and say, can you pull me the footage from yesterday when that white car behind me ran into me? Um, that is actually exempt. You are not required to provide it. Now, if law enforcement is involved and they want a copy of it, they're entitled. But security footage is exempt. Um, it's weird why it is. There's attorney general opinion. It's basically the basis behind it is that the person could potentially figure out the way your security system works, and that is the idea behind it. But this happens in a lot of my districts. Or they'll be like, my house got, God forbid, robbed yesterday between 7 and 8. Can you send me the footage of every car that came through the gate during that hour? No, you're not required to do that. It's exempt. Emergency notification numbers, bank account numbers, credit card numbers, direct deposit information, drug testing, patient medical records made by healthcare practitioners, active discrimination investigations, active litigation work product of the attorney. That's one of those exemptions I talked about where the attorney records might come into play. Blueprints and structural layouts of buildings. That gets back to that whole security issue. Not exempt from public records. Job applications, personnel files, salary and travel records, concluded investigation files, discipline records, telephone records, litigation files, once litigation is concluded, background check, criminal history is generally a public record. Now, one of the things that comes into play here is a lot of my districts, and I don't know how you handle this, but a lot of my districts do not maintain an email list of all of the residents. It's very useful, and I know you might want one, so you could do e-blasts and things along those lines. But if you have it, it is a public record. And so someone who wants to sell, I don't know, water softening equipment could contact you and say, I would like the email list of all of your residents in your park, and you would be required to provide it to them. So some of my communities don't maintain those for those reasons. All right, so what are the penalties for public records violation? Um, very similar to Sunshine Law. Knowing violation constitutes first-degree misdemeanor, up to 1 year in jail and or $1,000 fine, potential suspension or removal or impeachment from office. Again, that's not done by your fellow board members. It's not done by staff. It's done by government. Non-criminal infraction committed without the requisite knowledge is punishable by a not to exceed $500 fine. The above may be pursued by the state attorney's office. Also, there is a civil action provided by statute that allows for the recovery of attorney's fees and costs for violations of this law. So again, we find ourselves back to the same issue with the Sunshine Law, which is, okay, you're like, Andy doesn't know what he's talking about. I know what I'm doing. It'll be fine. So maybe I'll get a slap on the wrist. I probably won't. I doubt I'll serve jail time. I doubt I'll, get fined. But if the district gets sued over an issue that was caused by you and the plaintiff is awarded attorney's fees, you do not want to be the person that cost this community hundreds of thousands of dollars. This next case, and I know I've talked about it before because it's, again, just up the street, Sarasota area is like a hotbed for sunshine and public records issues. There is a couple of groups that are very, very smart in our area that file a lot of cases. I mean, the case law that has come out of here is applicable across the state. And these groups are particularly diligent in our area. This one, Lorenzo versus City of Venice. Here, the judge determined that the Venice City Council violated the Sunshine Law through emails and entered a judgment against the city of almost $780,000 in attorney's fees and costs. And by the time the city was all done paying that, paying their own attorney's fees, they had $2 million invested. So that would be bad. The next slide is, even if you don't take account of, even if you're not scared of the $2 million or all the other things I'm telling you, I mean, you did take an oath also. So it says, I do solemnly swear or affirm that I will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, that I am duly qualified to hold office under the Constitution of the state, that I will well and faithfully perform the duties of your district on which I am now about to enter. So help me God. So that's where it all comes from. What if you do screw up? Or what if you didn't even screw up, but there's a lawsuit filed against you? Then what happens? What do? So public officials and indemnification. So you have a right, first of all, and I assume this is true here, but districts have director and officer liability insurance. I assume you do here. So that's one level of support, because let's face it, you board members are giving so much of your time. As we keep saying, it is not for the money. Maybe it's for the glory, but you're giving so much of your time. God forbid that you should also be subjected to having some sort of judgment against you where you have to, pay from your personal fund. That is not going to happen. Never say never, okay? But most likely that is not going to happen as long as you are adhering to what you're supposed to be doing. That's why we have these trainings. That's why you're required to go through these trainings, so that you know what you're supposed to be doing and that you do it. If you punch somebody in the face at a board meeting, guess what? You're probably going to be liable for that, okay? Whether they deserved it or not. But public officials have a right to be defended when acting in the course and scope of their duty. So again, you're acting within the course and scope. You're not outside of that duty. You have a right to indemnification based on common law, based on statutory law, and sometimes districts have a separate policy as well. The right extends to public records and sunshine laws. All right, sunshine and public records headlines. As I said, this happens, and this happens around here. I mean, look at the first, we already talked about the city of Venice, the city of Sarasota. Now here's something from Holmes County. Here's something regarding New College, which is, everybody knows, just up the street, Sarasota-Bradenton area. attorney's fees is a big driver. Like it or not, unfortunately or fortunately, there's a cottage industry out there of teams wanting to sue government officials and government over violating the Sunshine Public Records issue. All right, so here's a little quiz for the public record. Our board members posted comments relating to district business on a privately operated website considered a public record? Yes, the board member would be responsible for ensuring that information is maintained in accordance with the Public Records Act. Can text messages be a public record? Yes. Does someone requesting public records have to explain why they want the record? No. Can a district require a person requesting public records identify themselves? No. As long as we have a way to respond. True or false? If a court finds the district failed to follow the Public Records Act, the court could award attorney's fees to the requester. True. So that's public record. Are there any questions related to that? Sure, go ahead.
Maybe I should ask this over 2 years ago. But I had the communications committee, and I've always considered I was on the communications committee. Am I a liaison? The chair.
So you're not a member of the board of trustees?
Yes.
Okay. But you're a committee member,
He's the chair of the communications committee.
and the committee, so you should not be, you are a committee member.
This time, as the chairperson, he is a committee member.
So you should not be, and this committee meets in the sunshine.
Yes.
Then you should not be communicating with your fellow committee members outside of a duly scheduled meeting.
Right. On that committee.
Correct. Yes.
Yeah, I was just,
And if you're a board member trustees, then obviously you shouldn't be talking to your fellow trustees. There's like no one you can talk to.
Except in the meeting.
You can talk to Vicky, you can talk to me.
Can you clearly define the difference between a chair, trustee, being a chair of a committee, and liaison as far, I mean, because I think sometimes we're using that interchangeably, and I mean,
Sure. A liaison is not a member of the committee.
and what makes them not a member of the
They don't
committee?
have any voting rights.
Okay, so our ACC chair, because we say he's chair, he does not, well, you do on a, if we don't have enough committee members, you'll vote, so he's never voting.
Okay.
But we're saying he's a chair. And so you would, are you voting or not? So I think that that's where the clarification
Yeah, I
gets
think
muddled.
You can participate. You're a liaison, okay? If you are truly a liaison, you're not part of the committee. You're a board of trustee member. You come to the meeting and you listen and you participate in all the discussions. But when it comes time for voting in that committee meeting, you do not get a vote as a liaison. Correct. And it's not like I get a vote, I just don't use it. It's you do not get a vote. Not always. I mean, I don't, it depends on how it's structured. Yeah, I mean,
So would it be advisable that our trustees that are on the committees, that they're liaisons?
yes, it should be liaison.
Trustee that's on that committee. We would restructure all of our committees that are appointed by the board to have board members as liaisons to those committees and then someone else on that committee would have to step up to be the chairperson of it.
That would be the best.
Okay, thank you.
Andy, I'm the chair of the Finance Committee. We don't vote on anything. We just make recommendations to take back to the board.
Okay, well, you still have to meet in the sunshine.
Yes, we meet in the sunshine, but we don't vote on anything. We discuss different things.
Okay,
So,
but still, if you're a member of a committee that has to meet in the, if you're more than just the liaison,
okay,
you're an actual committee member, you would have the ability to vote if you did vote.
okay,
Then you would not be able to be discussing things with your fellow committee members outside the sunshine.
correct. I understand that.
So
but-
I think it's best that you just call yourself a liaison.
All righty. Okay.
The only problem with that is that that would take us to restructure a lot of our documentation that has gone back for years and years and years. Because we have jobs, responsibilities that are assigned every year by the chairperson to the rest of the trustees. And we would have to go back in that document and change everything to a liaison and make sure that someone else on those committees are stepping up to be. So, I mean, we can do it, and it's obviously what you're suggesting we do,
Yeah,
but
you
it,
don't necessarily have to change the documents per se if this is how you're operating. I mean, it would be good if they match how you're operating, but operation trumps what the document says.
okay,
You know, so even though the document says, let's just say, the document says it's a 5-member committee, but you only have 3, okay? Well, you only have 3. That is truly what's going on. It'd be better if you, at some point, went back and changed the documents, if you intend to only keep it at 3, to say that it's 3. But what's operationally occurring is what's occurring.
all right, thank you.
Getting your exercise.
Thank you. I am the liaison for a group of organizations, per se, like the Men's Club, Just Us Girls, and what's the third one? And the H Park. So as a liaison in the Men's Club, where there are other trustees present, I should not be saying anything. That's the route I've chosen,
Correct.
is not just to observe. Now, can I come back to the trustee meeting and say something?
Absolutely. At the duly scheduled and noticed trustee meeting, you're free to discuss whatever with your fellow trustees. I mean, it should be agenda items, and again, all those things we talked about before. If it's not, then you might have to reopen public comment, etc. But what a lot of my boards do, and what I would recommend, is that you just have on the agenda liaison reports. And that at that point is when, if you have something to report on, you could just say, nothing new this month. We didn't meet, whatever. But if you do have something to report, that's when you would do it.
Okay. Thank you.
Sure. Anything else before we go to ethics? I think we're going to eat first. But and again, if you think of something, we'll talk about it later. No structure.
I can remember it, my brain's
Maybe
stopped.
I'll talk
The Finance Committee, I believe, does send to the trustees suggestions about budget. Is that a true statement? Yes, they're open meeting. We have a chairman of that Don, can he vote as chairman?
He can vote.
Well, my question is, how do they get agreement on what gets sent to the trustees for budget? That's my real question. And if they have to vote on it,
Whether they come to a consensus or a vote or whatever that they're doing, sounds like they have to meet in the sunshine because they're making recommendations, and they do meet in the sunshine. So I think it should be clear that Don is either a member of the committee or is the liaison. If he's a member of the committee, he can be, but he would have to be careful to discuss anything with his fellow committee members outside of a meeting. If he wants to be able to discuss something with one other committee member, because still 2 committee members couldn't get together to meet with him, but if he wants to discuss something with one other committee member outside of a meeting, then he should not be a member of the committee. He should just be the liaison to the committee.
I'd just like to know how they get consensus to move it to you, to the board, whether they vote or what mechanism they.
I mean,
Because
Don could speak to it. Obviously, I don't know exactly what
Hear your whole
procedure.
question, Cheryl, I'm sorry.
it's okay, I understand. My question is, how do you get consensus to move a budget to the trustees? Do you guys vote, or do you say, I agree with this one, I don't like this one? Okay,
All right, we go as a committee, we go line by line on the budget. And we say, well, we agree to this one. We all agree. Or someone may disagree, and then we'll discuss it.
and at the end, you just send what you all discussed
To the board, yes. We never typically vote.
You have input to that.
And
Exactly.
I would say, we're repeating ourselves, but I would say that is making a recommendation. They need to meet in the sunshine. They do meet in the sunshine. We're good. Sure.
Thank you.